Welcome back to the courtroom. Today's case centers on probation violations, missed alcohol tests, positive alcohol screenings, and a defendant facing the possibility of jail time and stricter supervision. What makes this hearing especially interesting is that the defendant quickly accepts responsibility, but the real question is whether the judge believes these violations are isolated mistakes or signs of a deeper problem. As the hearing unfolds, pay close attention to how the court weighs accountability against rehabilitation. Will the judge offer another chance, or decide that probation has already failed? Stay tuned, because a few admissions in this hearing could dramatically change the outcome.
All right, court calls the people of the state of Michigan versus Tammy Jo Paddock, case number 25-5204 SD. Appearances, counsel.
Lisa Dole for the people. Thank you, Your Honor. Taylor Ann Fervento on behalf of Ms. Paddock, who joins my counsel table.
All right, counsel, I know we're running about 10 minutes early. Is there any objection to taking the case early?
No, Your Honor. No objections, Your Honor.
All right, and we are here for a probation violation. It's alleged that Ms. Paddock has the following technical violations: that she failed to test as directed on March 18th and April 6th, that she violated probation by testing positive for alcohol on February 20th. Ms. Fervento, how are we proceeding today?
Thank you, Your Honor. My client will be entering a guilty plea to the technical violations of the failed to test in April, and then the two positives in April as well. And it's my understanding that the people are going to be dismissing the missed test in March. That is correct.
I only have one positive test for April.
Oh, you must have an older report. May I?
Oh, no, here it is. It just wasn't flagged. Sorry about that. Oh, wait a minute. So let's make sure she's been arraigned on the right one. And it looks like she has been. So, all right. So let me restate that then. So we have a failed to test on March 18th and April 6th, and positive test on April 20th and April 29th. Is that correct?
Yes, Your Honor.
All right. And the agreement is she's going to plead to the positive tests and the missed test on the 6th.
That is correct.
And dismiss the missed test on the 18th.
Of March. Yes.
All right. Ms. Dull, do you have any objection to taking those pleas as opposed to a hearing? Ms. Paddock, have you heard what the attorneys just said the resolution of the case is?
Yes.
And is that how you wish to resolve it?
Yeah.
Will you please raise your right hand as best as you're able? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
You may put your hand down. So as I stated, it's my understanding that you're going to be pleading guilty to the violation of a missed test on April 6th and a positive test on April 20th and April 29th. Is that your understanding of the plea agreement?
Yes.
Other than the agreement, has anybody promised you anything in order to get you to plea?
No.
Has anybody threatened you in any way?
No.
And is it your own free choice to plea today?
Yes.
Have you had adequate opportunity to discuss this matter with Ms. Fervento, and do you feel comfortable in entering the plea today?
Yes.
All right. Then to the allegation that you violated your bond by failing to, your probation by failing to test on April 6th of 2026. How do you plead?
Guilty.
And that you tested positive for alcohol, which would therefore be a violation on April 20th, 26. How do you plead?
Guilty.
And that you violated by testing positive for alcohol on April 29th of 26. How do you plead?
Guilty.
In order to accept those pleas, I must have you tell me what it is that makes you guilty. So did you know as a condition of your probation you were to randomly test?
Yes.
And did you also know that you were not to consume alcohol?
Yes.
Did you know that you were supposed to test on April 6th?
Yes. I was very sick.
Okay. All right. And did you test positive for alcohol on April 20th?
Yes.
And is that because you had consumed alcohol?
Yes.
Did you test positive for alcohol on April 29th?
Yes.
And is that because you had consumed alcohol?
Yes.
Do counsel believe the defendants provided a factual basis in which to accept the plea to the violations and that the court rule has been complied with?
Yes, Your Honor.
Let me ask one additional question.
Sure.
You were sick on April 6th. Did you do anything to notify probation on April 6th of your illness?
No, because I just knew that she.
So no.
No.
Okay. Nothing else, Your Honor.
You believe she's provided a factual basis?
Yes, I asked the court acceptably.
The court agrees. I find the plea is knowing, voluntary, and accurate. Ms. Paddock, I find you in violation of your probation by failing to test as directed on April 6th, by testing positive for alcohol on April 20th and April 29th.
This is a critical turning point in the hearing. Notice that the judge carefully counts and identifies each technical violation before moving forward. That may sound procedural, but it matters because every violation adds weight to the court's sentencing decision. The defendant has now admitted to missing a required test and testing positive for alcohol on 2 separate occasions. From a legal standpoint, these admissions eliminate any dispute about whether the violations occurred. The focus now shifts from proving misconduct to determining the appropriate consequence. What's especially notable is that both attorneys appear to agree on a recommendation that balances punishment with treatment. The court isn't just looking at rule breaking, it's evaluating whether the defendant is genuinely taking steps toward recovery. What do you think? Should repeated positive alcohol tests automatically result in harsher penalties, or should courts prioritize treatment when someone admits they need help?
By my count, that is 3 technical violations. Do the parties agree?
Yes, Your Honor.
Yes, Your Honor.
All right, so just let me make some notes here. So we pled. All right. I have an amended recommendation from the probation department dated May 1st. Have both of you, do both of you have a copy of that?
I do, Your Honor. Yes, and I've reviewed it with my client.
All right. Do either of you have any additions or corrections we made to it?
No, Your Honor.
No, Your Honor.
All right. Allocution then, Ms. Fervento.
Thank you, Your Honor. We would respectfully request that the court follow the recommendation of 15 days from the probation department minus credit. My client's taking responsibility here today. She acknowledges that she has a problem that she needs to address, and we would ask the court give her another opportunity. Thank you.
Thank you. Ms. Dole.
Your Honor, I ask the court follow the recommendation in this case. She did miss a test that she pled guilty to. There was a prior missed test that she initially was given a warning and she also tested positive for alcohol on 2 different occasions. So she definitely has a problem that needs to be addressed. To her benefit, she did start attending counseling, so she is doing some things to address her substance use disorder. So I believe continued probation is appropriate, in addition to the jail time and the requested 60 days of daily testing, or at least 60 days of daily testing. I do believe that she may want to keep that going due to cost of traveling. Thank you.
What do you mean the cost of traveling?
For random testing versus daily testing.
Oh, okay.
Cost her money to travel versus doing the
A significant gas cost, Your Honor, but the little machine is a lower cost than the cost of gas.
All right. Ms. Paddock, did you have the right to address the court prior to sentencing? Is there anything you'd like me to know?
No, just that I can't afford to drive back and forth every day.
All right.
At all.
So I went back and looked at your substance use assessment, and I remember it standing out to me at the time of sentencing, and it stands out to me again because it's written in such ways I don't see a whole lot of the time. And that's that you didn't have a substance use disorder because you were in remission, but prior to that you were severe.
Yes.
Usually I don't see that when it comes to remission. So that just, again, kind of stuck out a little bit for me. And I guess I have to question, based on the 2 positive tests, whether or not that assessment was accurate.
Right.
But I also realize that once you fall off the wagon, so to speak, it's kind of hard to get back on that. Some people are able to do it quick, others it takes some time. And so I do understand that. The recommendation in this case is for 15 days jail with credit, which would be 7 days credit. Am I correct, Ms. Bismack?
Yes.
And the additional daily alcohol testing, I believe, given the situation in this case, you were not on probation a very long period of time. You were on probation for about 3 months before we at least started to see a reported violation. I guess it'd be 2 months. The concern I have is that I had put you on probation for a year, and I'm starting to question whether or not that's long enough given what we're starting to see. Especially with the 2 positive tests. The missed tests, I don't know what happened with the first missed test. I'm guessing maybe that was around the time of the ice storm. Maybe that had something to do with it.
Yeah.
I don't excuse the missed test that you did plead to, but I can at least somewhat understand it. What's more concerning to me are the positive tests. So what I'm going to do is I'm going to continue probation. I am going to order 15 days jail. With credit for 7. 60 days of daily testing. Oops, I can spell. And I'm going to extend an additional 6 months. So that would put us to June 28th of 2027.
July.
Yes, thank you. July 28th of 2027. The previous fines and costs in this case, Crime Victims' Rights Fund fee of $75, state minimum fee of $150. I'm sorry, $50. Fine of $150, court costs of $150, attorney fee of $150, and probation fee of $180, along with reimbursements of $300 to MSP and the prosecutor. I find were adequate and appropriate at the time of sentence. I again find they're appropriate today, with the exception that there's going to be an additional it would be $90. This new law requires me to do too much math because you're still going to be eligible at halftime, even though we've extended it out 6 months. You're going to be eligible 3 months before that. So I'm only going to charge you an additional $90 for probation fees. I also find that at the time of the original sentence, you had received $20 credit back towards your fines because you had sat some jail time. I believe that $20 is still appropriate. So to sum up, probation is continued. It's extended till July 28th to 27. You are to serve 15 days jail with credit for 7, 60 days of daily alcohol testing. You are still eligible for early release. Fines and costs are preserved, except with the additional $90 for probation. Do you have any questions for me about your probation sentence today?
Yes. What if I was to pay all the fines off?
That's fine. There's nothing that stops you from doing that.
It's not gonna help.
Help in which way? You mean
Right.
reduce the?
Yeah,
No, because I'm only charging you for what you're required to sit for on probation. So you're going to have to sit that period of time anyway. So as far as
oh, right, I mean,
paying everything off, there's no benefit to paying that off early. The mere fact that you pay off, because to be honest, the law says that when I impose sentence, you're required to pay that day. So there's no benefit to paying today.
Oh.
All right. It's by grace that we extend it out over the period of probation.
Oh.
All right. Any other questions? Ms. Dole or Ms. Fiorvento, anything else in the judgment?
This hearing highlights one of the most challenging issues courts face: balancing accountability with rehabilitation. The defendant admitted to 3 probation violations, a missed alcohol test, and 2 positive alcohol screenings. After reviewing the facts, the judge accepted the guilty pleas, found the violations proven, and imposed a sentence that included 15 days in jail with credit for time already served, 60 days of daily alcohol testing, and an additional 6 months of probation. The judge's comments suggest the biggest concern wasn't simply the missed test, but the repeated positive alcohol results and what they might reveal about the defendant's recovery progress. Rather than revoking probation entirely, the court chose continued supervision and treatment-focused monitoring while extending the probationary period. This outcome serves as a reminder that probation is often viewed as an opportunity, but it also comes with strict obligations that courts expect individuals to follow. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.